Welcome, viewers. This is Major General Neelendra Kumar for the YouTube channel Lex Consilium Foundation, and in conversation with Advocate Anil Malhotra on the issues relating to the teaching, understanding, learning of international family law. And in part two, we come to question number 6, that we are aware of multiple burning issues that come to surface with regard to maintenance for women, grant of alimony, or permanent maintenance in the divorce cases. And these are coupled with property division, financial settlement, and also with regard to the issues in India for implementation. And obviously, this happens when one of the spouses is living abroad. Now, with regard to these issues, Anilji, what's your experience? How do the Indian courts deal and take up such matters?
Sir, coming back again to our legislations, the Hindu Marriage Act in a divorce petition talks of interim maintenance, permanent maintenance, alimony, property settlement as ancillary issues to the main divorce petition. Independently, you have maintenance under the Criminal Procedure Code, Section 125. You have the Hindu Adoption and Maintenance Act. Now, all these laws which we have made in India, we have been following a need-based maintenance law. Meaning, there are no strict parameters. It is a case-to-case determination. And there is no equitable sharing or division of matrimonial assets. For example, abroad, everything is divided half and half. Now, we do not have any such system. We did not lay down anything. So, in every court, in every case, the court tries to do justice. And I think our courts, maybe maintenance, maybe custody, maybe marriage, maybe divorce, they try to do their best. And of course, the High Court and the Supreme Court really go into things to resolve matters and help you. But it was a grey area. And for a foreign jurisdiction to understand this was absolutely outlandish.
Yes.
They couldn't believe it, they couldn't understand. Then a very elaborate judgment by Justice Adv Anil Malhotra in Rajneesh vs. Neha laid down guidelines under Article 142 of the Constitution. Simply because there is no law, so by law was made through the judgment. Now, this is another concept which is coming up in our family laws. The Supreme Court lays down practice directions, guidelines, or interim measures. Standing in a classic case in Vishakha. In Vishakha, the Supreme Court laid down guidelines for preventing sexual harassment in workplaces. And after 15 years, an act was made. So this is the way I think the family law is also going now. 142, you lay down guidelines, you lay down principles, or you lay down parameters. And under Article 141, as you know, whatever the Supreme Court says is final. Meaning, the Supreme Court can review its own decision as a court of record, but every court below the Supreme Court has to follow whatever is the law. And the Supreme Court can differ and change the laws. So Rajneesh vs. Neha has laid down very good criteria. Meaning, if you are filing a petition, you will file an affidavit making a clean bone of your assets, your properties, your liabilities, both spouses. You will make out a case on figures of what you want. You will make out a case of what you have contributed, or what you did not contribute, but you raised the family. Because earning is not earning, building a home is also earning. It's an investment. So this has brought up a lot of practicality. It has fallen into place. There is some kind of a coherence, meaning in family courts, you have to file an affidavit. You can't conceal, you can't mistake, you can't lie, you can't say. You can't say, I have no income. Or you may be having a lot of income by cash. You may be living in a luxury house, you may be driving in a good car. But you say, I don't pay tax. That will not let you get away. And the courts have also started saying that if a woman is abandoned by somebody living abroad, then she has to be maintained by the same standards which she would have been using and which the other spouse is enjoying in the jurisdiction, and pay her an equivalent.
So the legal approach is evolving.
There is the court is evolving an approach. There is cohesion, there is semblance, there is some sense in Supreme Court particularly evolving principles to put the system in place. Otherwise, then comes the question of enforcement.
And this approach is problem solving.
Problem solving to a great deal of extent, but the biggest problem is that if there is a financial decree passed for maintenance, for settlement, and the other spouse abroad absent, how do you enforce it? You can take a precept and execute it in the foreign court, but the cost of executing that in the foreign court will be more than what you actually get.
Yes.
Getting a claim against the assets in India, getting bound down to execute the decree of the foreign court or the Indian court in India. These are issues which need to be sorted out sitting across the table by signing conventions of the Hague. The 1980 convention has thereafter got the 2006 convention, 2003 6 convention, 7 convention. I have been. I recently went to the US to take part on behalf of India and as Secretary of the Child Relocation Committee of IFL on child removal. They are talking. There were about 100 delegates in different countries in a closed-door atmosphere in the Canadian Embassy in Washington, and they were talking about principles of relocation. Meaning, if you are split, then how are these spouses going to be maintained? How are the children going to be taken care of? Now, we have not even reached the top, and they are at the pinnacle. We are at the bottom. But then I contributed to say that our Indian courts do a very good job in evolving on a case-to-case basis. For example, the Supreme Court is saying we are dissolving a marriage and we are giving you 10 crores alimony. Or we are giving you lifelong stipend or this amount or that. And it's a practical amount. It's not peanuts. And they tell both parties, listen, if you want to settle the matter, you have to lay the floor open. You want freedom, you get it. Pay for it. The non-willing spouse is brought up a family, is brought up a home. She has contributed. Give her a slice and things get settled. But then you have to use the arm of the court. The court has to do, let us say, wrong phrase, arm twisting. But then we have also developed a mediation and settlement position, meaning there is in Supreme Court, for example, senior advocates are a part of the mediation system. The matter is referred to a mediator, be it child custody, be it maintenance. You go and sit there, talk to a senior lawyer, come out of the package and resolve the issue.
Okay.
But then, sir, we have to put all these things in our statutes. We have to amend our laws and we have to get a system. See, understand the problem of the family court judge. He has to read the law. He has to go back.
All these decisions will form the component that would be available to the lawmakers when a new sort of legal regime is proposed or a statute is being drafted.
Sir, I'm sorry to say that for the parliament, family law is a poor country.
Yes,
It is not a priority.
yes,
There is no time. Nobody wants to touch family law. I don't know why.
right.
Therefore, our family courts are stuck in this whirlpool of statute. You can't expect a family court judge to talk about 142. The moment he does it, the High Court will say it. Or if the High Court will do it, the Supreme Court will say it.
Anilji, but practitioners like you are also crusaders. They would want a reform. Now, shall we?
I do a lot of amicus. I write written reports. And I am a soldier and I want to change. I have spent 40 years earning and learning. Now I want to give back to the system which
Right.
what the system gave me.
Very
So that-
creditable.
So I can improve the conditions of family law and family law situation in India. We need family court judges. Sitting in Chandigarh, the most modern city in India, with a population of 30 lakhs, we have the maximum matrimonial litigation. But I'm so sorry to say, we don't have a family court. We have a building, we have a judge sitting in the family court, but he's not the family court because the rules are not being notified.
Yes.
Look at
That's
the
a pity, but let's hope something will move in that direction. And now I would seek your attention to something equally important, and that is with regard to instances of matrimonial cruelty and domestic violence. Now, in these aspects where the penal laws also come into play with regard to a wife in India, when the husband and the entire family, they may be abroad, and cases are quite common. They are multiplying. Now, has been the approach to resolve such disputes of such a nature?
Sir, the sad part is that the good part of these laws, meant to succor relief, meant to provide help, meant to remedy a wrong, have become a system of organized abuse. 498A, unfortunately, matrimonial cruelty, dealt with the dowry provisions, is becoming a very, very vulnerable remedy which is meant more or used more to intimidate, to further aggravate the matter and rope in the entire family. And the High Courts and the Supreme Courts are now very, very regularly setting aside these decisions in the jurisdiction under 226 or 32. It is unfortunate that we, instead of sorting this out, we imported another law, Protection of Women Against Domestic Violence Act, 2005. According to me, the act is also becoming a remedy for misuse.
Okay.
Who takes you to a magistrate straight who, without evidence, in a 6-month proceeding, which ought to be concluded, can give you a residence order, can give you a restraint order, can give you a child custody order, can give you maintenance. There are 7 different reliefs which you can get for the asking. And all that it needs to be done is that the lady should be living in the jurisdiction of the court on the date on which she files the petition.
All these aspects can be taken care of.
They can be, but you flee with the child, you come to India, you start living in a place, you go to the magistrate and file a DV petition. Nothing has happened there. No cause of action, no occurrence. But the provision says, there you are. Now, though it goes to a magistrate, it is said to be a civil remedy. You go to the High Court in a question under the CRPC section 482. some high courts say, oh, this is a civil remedy. How are you come to me? Go under 226. Now, the question is, whether it is 482 or 226, it's an abuse of the process of law. If you go to Supreme Court decisions, let's say Pepsi Foods, let's say Bhajalal, they say it doesn't matter what hat the judge is wearing. He's a High Court judge, whether he's doing 482 or 226, hardly matters. But all the same, we have created a law for a European atmosphere into a system which is domestic and Indian. A woman can get maintenance under the Hindu Marriage Act, Section 24. She can get maintenance under 125. She can get it under the Domestic Violence Act. And all these are separate and available independently. Quantum may vary up and down there and then. But then why do we have multiple remedies in different situations? Why can't we have a uniform law in this process? Why can't we have a better enforcement system of one law in which everything is there? We need to take stock. Instead of bringing in a law in 2005 to be added to a law which we made in 1860 and then in 1973 in the CRPC. So we are making a pool and we are throwing everything into the pool and the filtration plant is not working.
Yes, that's there.
And you go to a sub-division or you go to a class 1 magistrate, judicial magistrate for one thing. You go to a senior civil judge for another thing. You go to the family court for another thing. Why can't we put all the eggs in one basket?
Yes, we want a single window clearance or a solution.
We want a single. We need a more balanced, equitable law,
and that will cut down the agony and problem of those who are affected by such problem.
Put all the eggs in the family court.
Right.
One.
Now, moving beyond these domestic violence cases is the issue of orphan, abandoned, and surrendered children. And this is from the spectrum of Juvenile Justice Care and Maintenance Protection of Children Act 2015 on one hand, and on the other, the Hindu Adoption and Maintenance Act of 1956. Now, if we look the issue of such children that I mentioned, I would like to ask you and get your views. What laws presently prevail in India to facilitate movement of such children who may be orphan, abandoned, or surrendered to foreign countries, and what are the common complexities noticed in such cases?
So, first of all, let me clarify. From today's perspective, there are two problem areas in adoptions. One is orphan, abandoned, surrendered children, and the other is inter-country relative adoptions, or intra-country, of course, can be resolved.
Yes.
Now, let us first look at orphan, abandoned, surrendered children. Now, we had no law in place, and trafficking of children from India was a roaring business post 1980. Three decisions of the Supreme Court, Lakshmikant Pandey 1, 84, 2, 86, 88. Supreme Court said this is serious. You need to make a law. You need to find a system in place. Now, if we wanted to find a system in place, we had to first get into a machinery and a mechanism whereby we could join hands for adoption of Indian children, which were huge, 12 million plus, to find homes. So we signed the Hague Convention on Adoptions 1993. We became a part of the convention. We also signed the United Nations Convention on the Rights of the Child, which was already there. Now, we had a Juvenile Justice Act in 1986. We had one in 2012. Then what we did, when we created or amended the Juvenile Justice New Act, that is Juvenile Justice Care and Protection of Children Act 2015, we created a mechanism and machinery for intercountry adoptions by incorporating the provisions of the Hague Adoption Convention. So when you sign an international convention, you have to make a domestic law to give teeth to the laws in the convention by incorporating them in India so that then only Indian system can operate. So we had a body called Central Adoption Resource Agency under the Ministry of Women and Child Development. In 2015, CARA became Central Adoption Resource Authority with quasi-judicial functions, meaning they would determine best interest and welfare. So we fell into a place, we fell into a system, meaning if I wanted to adopt an orphan, abandoned, surrendered child abroad, I would apply to the central authority in my jurisdiction abroad. They would send my request to India if I wanted an Indian child. They would assess me. They would then go to the orphanages or homes which are recognized in where children are kept. They would match my particulars. Then they would facilitate a meeting. And then, if all went well, they would seek a resource, they would seek verification reports. And then it was supposed to go to court to approve it. And then the child went.
Quite an elaborate process.
It was an elaborate process. It was meant to work very well, but it is full of bottlenecks. It is full of technicalities. It is full of, what do I say, problems created which were supposed to make the process simple but have made it more complicated.
Okay.
They said the courts are very slow, so they changed the word court to magistrate. So now the whole thing in the end goes to a district magistrate who is supposed to make a recommendation on the basis of a report prepared by a child welfare committee or a committee domestically created, and then the executive magistrate sends it to CARA, and then CARA sends it. The question which I ask myself is, has a district magistrate got that learning, judicial acumen, wisdom, or understanding of the law or all the best interests of the child? A district magistrate is a multifunctional executive authority, not a judicial authority, who is armed with issuing all kinds of licenses, quotas, etc., etc. Is a child a commodity for whom an executive magistrate has just to take in the blanks? No. So then the process is so slow. Hindu carried a very big article the day before yesterday saying the process is very tedious, very slow.
This needs a relook, according to you.
Sir, according to me, needs a relook. And what we really need is CARA is full of administrative officers from the Ministry of Women and Child Development, executive officers, senior officers. I think CARA needs to be headed by a retired honorable judge, either of the Supreme Court or a Chief Justice of the High Court.
Primacy is to be given to the welfare and interest of the child.
And sir, you are performing quasi-judicial functions under the Act. You are reporting to a foreign jurisdiction in respect of matters relating to children, where you learn, where I think your training, acumen, and wisdom in the chair of a judge is more important.
Yes.
For example, JAG is full of people who have legal training. You can't have an ordinary army officer sitting in JAG because he hasn't got that input.
Yes.
So the biggest flaw, I think, in CARA is that they take things at random, they do things on their own, and through the adoption regulations, which are subordinate legislation, they are changing the Act. I give you an example. Under the Juvenile Justice Act, Section 56(3), Hindu adoptions are out of the purview and are exempted from the application of the JJ Act and the adoption regulations. Very clear. Because Hindu Adoption and Maintenance Act prescribes giving and taking, small ceremony, no paperwork. If you do a registered deed, it's extra. But the adoption dates back to the date when the adoption is formed. It's like getting married. You may do a ceremonial marriage, register it after 20 years. The date when you did the adoption will date back to the date of the adoption, not of the date of registration. Now, Kara is making rules to undo Hindu adoptions. So they are saying, you did this deed on so and so date, we have changed the regulations. Now you, despite having done this adoption, approach the country where you are going to take the child and ask it to do the adoption. That country has no clue about what has happened. I have recently done a matter in the Supreme Court where the Supreme Court has set the record straight, but they are very, very unhappy about the decision. So we were trying to create a solution, but we have ended up in making a more complicated situation.
Yes.
So therefore, again and overall, somebody with the wisdom, learning, and acumen of a person like this Nilendra Kumar, General Nilendra Kumar, I must say, has to step in and do more lectures on this point and create a movement with more supporters like me to find a solution.
I'm sure that Anil Malhotra's views in this would be heard by the authorities to be, and at the proper quarters, action will be taken. With this, I move to the next question. The last 2 decades have seen a number of cases, I won't say a spurt of cases, but a number of cases relating to surrogacy. And the recent legislative efforts or legal efforts on curbing surrogacy in India have been made by the parliament. Law has come in place from 2021 onwards, if I'm correct. Now, I would request you to please flag the salient points of this law, and can now the NRIs or the foreign citizens undertake or seek surrogacy benefits in India?
So, surrogacy is something which you find in Hindu mythology. 100 children born to the Lord, and you hear of things. Now, I think if having authored 2 books on surrogacy out of the 10 books, in 1995, the Indian Council for Medical Research made guidelines. And that's when it all started. So surrogacy was allowed for anybody and everybody, simply for the reason that there were no foreign nationals, Indian citizens, men, women, blah, blah, blah. Single women were also allowed to do surrogacy. So 1995 onwards, because adoptions were very difficult, people stepped into surrogacy. Because genetically you got one parent's genes if the other parent couldn't contribute. Or you both contributed, you didn't want to undergo the process, so you hired a womb. This graduated from a philanthropic act to a problem-solving mechanism of having progeny when, unfortunately, one or the other spouse had medical disabilities. This proliferated into a multi-crore industry by the year 2000. So, whether you were gay, whether you were single, whether you were Indian, whether you lived in India, nobody cared. You came to India, you did surrogacy, and you went back to Israel as a gay couple, or you went back to the US, or you became film star X, or somebody like you in the media industry. Why single parent, 1 children, 2 children, film actor, film producer, blah, blah, blah. We even have a very popular foreign star who is now an Indian actress married to a foreign husband who has two children by surrogacy. I can't take names, but still, everybody was happy. Women who hired rented rooms were very happy because they got money to nurture a family with 3 children or 5 children. The ones who wanted children were very happy that they got a child. Doctors, hospitals were very happy because it became a flourishing business. Then came Baby Mani Abda's case in the Supreme Court, where Justice Laliji Prasad said, we are a baby farm industry now. We are multi-crores and whatnot's going on. This was a case where a Japanese couple came. The woman didn't contribute, the father had contributed, child was born to them. By the time the child was born, they were divorced. The woman said, I had nothing to do with it, the child.
Yes, that's Justice Pasayat's decision some years back.
Baby Manji Yamda. So Ikibo Yamada, the grandmother, and the man couldn't take the child because he was the father and he couldn't have a single female child with him. And then he brought in his mother, and the Supreme Court, under Article 32, directed the Indian government together, giving him a visa so that the child would go. Then came Jan Bala's Gujarat High Court. Twins born to a German couple. The Gujarat government gave Indian birth certificates to the surrogate mother, declaring them to be Indian because they were born to her. The government of India came and appealed to the Supreme Court and said, these are foreign children, how can you give them Indian citizenship? Then came a dispute. So the Supreme Court said, just let the children go. So they gave them a green go and the children went away. And then this is going framed with a lot of questions. And the Supreme Court started openings. Then, slowly, the government changed its thought process. And by 2010, they started taking out, the government of India started taking out administrative office orders, deciding who will do surrogacy, how will surrogacy be done, who is barred, who is not barred. I challenged one in the High Court of Punjab and London, where a single man in Sudan said, I want to adopt, I want to have surrogacy, what's wrong? So the government of India said, we haven't made a law. Now this is carried on till 2020. Bills were made 3 times, doing different things. But then, nothing got resolved till 2021.
So 2021 onwards, there is a law.
No, after 2021 came the law. The Surrogacy Regulation Act and Artificial Reproductive Technology Act 2021 are the first laws made by Parliament which are in place. So from 1995 till 2010, there were no guidelines, no regulation except the ICMR guideline which allowed everything. 2010 came a bar, OCI's foreign nationals barred. You could do it domestically in India. Then, of course, nobody bothered. But now, under the 2021, even for Indians, there are restrictions. 5 years of marriage, proven infertility. Initially, they said you can only have a surrogate within the family. Now, which family is going to have a relative lady to give birth to a child within the family as a surrogate?
Anilji, this matter is to be viewed from different perspective. You see, for example, that we have now medical tourism in India. The service providers aspect is there. There are issues relating to human rights, gender rights, feminism. And so therefore, and also there is a law relating to organ transplant. Perhaps the spirit behind one or more of these aspects that I mentioned would be applicable in matters pertaining to surrogacy. And therefore, you would agree that it is based on the experiences that the law would evolve. We have now something that came up in 2021, and when its efficacy is tested, then only requisite changes as needed can be seen.
Sir, I agree with you. But look at what is happening. Everything has gone in the grey market. Yesterday only, there is a big news about a surrogacy exposure of some place in Hyderabad, whereby all kinds of, see, you don't know what is being implanted in you. You have an embryo. There was a time when cryogenic jars, fetuses embryos would be brought in, or sperm would be brought in and impregnated. But nobody knew what was going on till you went to the embassy and they said, get a DNA test, and it was not yours. What has happened is, in the clamp down, the stamp down from a free trade has converted the area into a grey market. We banned it, everything shifted to Nepal. Earthquake came, everything went to Thailand. Thailand, there was a problem, it went to Vietnam. Now it is Georgia and Washington. What happened in the war? When Russia invaded the country, now in the country, there were thousands of babies in underground rooms because there were no claimants, because of lack of identification of genetic material. So these kind of situations law cannot take care of. They have to be respected. But according to me, what the law should have done is they should have created an agency like CARA. They should have started testing and regulating people, whether you are a foreigner, whether you are Indian or whatever. There should be strict criteria. Test the people, evaluate them, say yes or no, allow them to do surrogacy.
Okay.
Now, by doing a clamp down, you have closed it. I understand there are ethical issues. There are issues in the Christian religion very seriously objecting to this. But sir, we have allowed the trade to flourish. You must also realize
Yes.
that there are a lot of women who said what is wrong. I remember we once,
Yes.
one of our surrogacy books launches in Delhi, when the law came, there were women all over with blindfolds on their mouths outside standing, saying nothing.
Right. So that's why different stakeholders, their views have to be taken. And here we come to the end of part 2. Stay with us. This conversation with Advocate Anil Malhotra on international family law will continue. Thank you.
Thank you very much, sir. And I want you to be the general in reform of family law, where I will be your soldier with a 303.
That's a good one, Anilji. We'll continue. We'll continue.
I think only when you say shoot, and you are never going to say shoot.
Thank
you, sir.
Thank you.